Civil proceedings, it was stated as follows. One, see that the court always, in the interviews of the judge, they always ask them about the Stellenbosch Farmers Winery case. State versus Fing, it was stated how to deal with disputes of facts. It is equally true that findings of credibility cannot be judged in isolation, but are required to be considered in the light of the proven facts and the probabilities of the matter. So, if you look at the Stellenbosch Winery case, where there is a conflict of fact between the state and the defense cases, it's like in this case, the proper approach is for the court to apply its mind not only to the merits and demerits of the evidence of the state witnesses and the defense witnesses, but also to the probabilities of the case. It's very important to look at the probabilities, as probabilities play a role in both civil and criminal proceedings. Is necessarily fully revert to be summarized correct approach, as I stated in paragraph 5 of the Stellenbosch Winery case. The matter was held in the SCA in paragraph 5, stated as follows: on the central issue as to what the parties actually decided, there are two irreconcilable versions. So too on the number of peripheral areas of dispute which may have a bearing on the probabilities. The technique generally employed by the courts in resolving factual disputes of this nature may conveniently be summarized as follows: to come to a conclusion on the disputed issues, a court must make a finding on, firstly, the credibility of the various factual witnesses, b, their reliability, c, the probabilities. The court's finding on the credibility of a particular witness will depend on its impression about the veracity of the witness. That in turn will depend on a variety of subsidiary factors. It's mentioned there: external contradiction, the witness conduct and demeanor in the witness box, his bias, latent and blatant, internal contradictions in his evidence, external contradictions with what was pleaded on or put on his behalf, or with established facts, or with his own extraocular statements or actions, the probability or improbability of particular aspects of his version, the caliber and contingency of his performance compared to what the other witnesses testifying about the same incident or event. A witness' reliability will depend, apart from the factors mentioned under these paragraphs. It's mentioned above, the opportunities he had to experience or observe the event in question, the quality, integrity, independence, and of his recall thereof. It goes on and on. It also deals, state versus Saul is also dealing with that particular matter. It's been fully canvassed in my heads of argument. For the sake of time, I would not deal, but the Stellenbosch Winery case is a very important case that the court must look at in order to decide regarding whether to acquit the accused or whether to convict him. If there's no positive proved facts from which the inference can be made, the method of inference falls, and what is left is mere speculation and conjecture. Your Worship, if I can just go to that, the action of the people that were actually present on that particular scene, and the issues, the safety features relating how and a person is trained to always keep the firearm pointed in the safe direction, away from the people, which is what has been done here by accused number 1, if you look at the video. Even the person that handed the firearm over to the accused, if you look at the 9mm, he didn't point it towards the accused. He kept it at the safe direction. Pointing towards the safe direction is then when it's handed over. You always keep your finger off the trigger until it's ready to fire. All these have been observed if you look at the video. You always treat the firearm as if it were loaded. other words, at a 90-degree angle before it was discharged. It can be discharged. Always know the target and what is beyond it. Accused number 1, if you look at that video, he doesn't fire shots anywhere. He fires it towards the air. If you look at the video, there are submissions that it could have been, the tent should have been, or the stage should have been damaged. No, it's not correct. If you look at where exactly accused number 1 went to go fire that shot. Right to the very end, taking out his hand, pointing the firearm towards the air, and then fired shots. That submission that he would have damaged anything there, it just cannot be true if one look at the evidence. It's submitted that over and above the direct evidence implicating the accused as the perpetrator of the offense, the cumulative effect of the probabilities pointing in the same general direction may be such to establish the guilt of an accused beyond reasonable doubt. His actions must also be looked at on the day in question, how he conducted himself. It's an important factor that needed to be considered. I've referred the court previously to State versus Boza and another in 2 LJ said the following would probably give effect to the wishes of society and the purpose of the Constitution. An innocent person must, as far possible, never be convicted of an offense. I agree completely with that submission. The conviction of a guilty person must be obtained with the best possible endeavors. The Ramaitim remains silent, and the satisfaction of the onus which is on the state must be satisfied as far as possible. It's our submission that we have satisfied the onus that was placed on us. The rights of an accused are very important. That is our submission. The right of the community to see that justice is done is equally important. To achieve these goals, instruments should be used in such a way that justice is done to everybody. It's my submission that the state has proved its case beyond reasonable doubt, and this court must distinguish the branches from the leaves in light of the totality of the evidence and reject accused number 1 version. Must look through the dust and the smoke and look at the evidence as it is. In concluding, the first principle of judging is, according to Lord Brown Wilkinson, that dirty dogs don't win. They submitted that acquitting an accused one in light of the real evidence presented in this case will bring the repute of the administration of justice into disrepute, and it will open a Pandora's box where everybody will just run around with firearms and claiming that is toy firearms. Accused 1 and 2, in my submission, you also defeated the proper administration of justice by removing. They're the only ones that could have removed. I want the court to look at that inference, remove the rest of that spent cartridge from the scene, and conspire to remove or replace the bolt assembly of the rifle SPA to affect the outcome of the ballistic results. When they realized the police retrieved the spent cartridge case from the scene. Upset about the Carl Lewis in the State versus Jalim, that a criminal trial is not a game. If accused one wasn't certain about his guilt in this matter, I would have conceded such and assisted the court to acquit the accused. It's not a criminal game, and the judge's position is not merely that of an umpire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He's not merely a figurehead. He has not only to direct and control proceeding according to the recognized rules of procedure, but to see that justice is done. I submit that in the circumstances, a strong case has been made out by the state against the accused, with the evidence being supported by real evidence in respect of all the charges listed above. I will submit, Your Worship, that accused number 1 be convicted of all the charges. Alternatively, that the court look at that section 257 as an accessory after the fact. As I explained to the court, my understanding, and as it's explained in Snyman, doesn't matter what the other accused, what type of offense accused number 1 committed. If accused number 2 assisted him thereafter, he's guilty of all those type of offenses that was committed by accused number 1. In this case, we submit that he's the one that had that Bridgebrook place, because coincidentally on the day when the police arrived there, this firearm apparently arrived from Port Elizabeth or from Gauteng, where it was apparently, or Johannesburg, where it was. It arrived now in KZN just as the police arrived. It's too many coincidences. Your Worship, that's basically my argument. Just one small issue that I want to deal with, Your Worship, in relating to the charges. The charges, if I've looked at my learned friend's counsel for accused number 1 argument relating to what exactly accused is being charged with, and how it looks like an attack about my inaccuracy on how I listed the charges. It is not correct, Your Worship. Accused number 1, if you look at it, at the charge sheet, it refers to, as I stated, after he's been charged, after the 2.2 Remington, my former colleague put in N.O. firearm of a caliber, of an unknown caliber, N.O. She didn't just stop there at the 2.2 Remington. It's my submission, Your Worship, that when she referred to N.O., she referred to the other firearm that was also seen on the video that discharged that particular firearm. If the submission is made that I want to adapt the evidence to suit my case, that is not correct in the act of argument of counsel for accused number 2. I think I must just address it. The word "and" is used to connect words of the same part of a speech, clauses. That's according to Oxford Dictionary. I didn't draft the charge sheet. But she put in "and/or." She knew about the .2223 Remington rifle, and she added "and/or," used to connect words of the same part of speech, clauses, and sentences that are to be taken jointly. Its meaning of "and" used to introduce an additional comment or interjection, like bread and butter. Bread and butter, Your Worship. The accused number counsel's issue relating to that can also be dealt with section 86 from a section 84 dealing with charge sheets up to section 88 deals with that issue if there is a defect in the charge sheet. In this instance, counsel for accused number were given everything that was in the docket. They were given those both video footage relating to the handgun. They were given the video footages relating to the rifle. They were given possession of the video footage, the viral video footage. It's not that they've been taken by surprise about this. If they haven't prepared accused number 1 to answer on those particular video footages, it cannot be now laid on the state's door. That is my submission. The purpose of section 87 is to inform the accused of the charge, to allow and enable him to prepare a proper defense. In other words, it is to inform the accused on what evidence will be brought against him and not how the evidence will be presented. Section 84, it deals with the charge sheet. I can go on and on about it, Your Worship. And where charge sheet, section 86(1) deals with whether there's a defect. In my submission, there was no defect in this particular charge sheet. Thank you, Your Worship. That is basically my submission.
Sorry, Advocate Rodis, Advocate Caesar, on one aspect regarding your Advocate Caesar.
Yes, ma'am.
One aspect regarding your address. I would like to reply on it, and if you are not ready to reply, you may do so as per norm after. But if you are asking the court to look at the provisions of section 257
Yes, Your Worship.
of Act 51 of 1977,
Yes, Your Worship.
is it not pertinent for the state to allege that in the charge sheet prior?
Your Worship, my understanding of, I stand to be corrected on that point, Your Worship. My understanding that an accused may not be charged for a particular offense on that particular nature. It is my submission that it's not really needed to be alleged in the particular charge. And that's why it's drafted in that way and constructed in that way, that it doesn't matter what the other accused did, that the accused after can be convicted of an accessory after the fact.
And you also maintain that in light of the statutory offences faced by accused persons.
That's correct, Your Worship. I had to go to Snyman to understand what it meant, Your Worship, because I wanted to be accurate on that point, because that section is so confusing. It's so long, if I can put it like that. Snyman makes it clear that it's obvious the one accused would never be present if you convict him or the other one of accessory of the fact. He came in afterwards. Your Worship, I just need to submit that is my interpretation of it. It doesn't mean that it's an accurate interpretation.
That's why I just asked your input and clarity. I leave it at that.
Yes. Your Worship, is there just one aspect that I left out? Just one. The issue about the DNA, the touch DNA that was also on their heads of argument. Your Worship, you would not find touch DNA of any of the accused in this instance. This firearm was already out of the province. Even accused number 2 is the one that gave or brought the firearm back for ballistic test, and his fingerprints still were not on that firearm. So that is not an issue that shouldn't be decided. Courts have convicted the accused persons on much less evidence. If you look at section 208, if my memory serves me correctly, of just a witness, a single evidence of the single state eyewitness. Thank you.
All right, my last question, and then I'm sure the defense will elaborate on that. I think right in the beginning of the proceedings, it was mentioned that the defense for accused 2 had requested further particulars, and I recall vividly I asked you whether you were aware, because that was the first day you came on record. You said no. I assume now you are aware.
Yes, Your Worship.
But I also indicated that that request and that reply is still not part of the charge sheet before this court.
It should be.
It should be,
Yes,
but
yes.
it's not, and I do not have it to retrieve it to attach it. So maybe it's in the court file where it is headed, but no one has attached it to the charge sheet,
It should have been.
which the court has to have insight in. So I'm just placing that on record. So if need be, I would greatly appreciate having insight in the request and the reply.
Worship, I will try to find it. I've seen it in one of the files. but I'm sure council will have it with them.
Also,
Since I came in after,
but not there.
after
no,
the
that's-
fact.
No, no.
Sorry, I don't jump off. I saw me.
Advocate Matthew, I've got broken legs, hips, arms, so I fully understand. All right, let me just get to you, Advocate Otis, just a minute.
So now approach the floor.
Certainly. Thank you. I'm ready for you to proceed.
Thank you, Worship.
Advocate Otis.
Worship, I'm going to start with some opening observations, if I may, and then I'll go into the argument. Firstly, I reiterate my apology for being late this morning, Worship, but we were told that the match was starting at 12. But that being the case, we also didn't anticipate that we'd be required to express our view on our own heads of argument. But I think I have to follow the pattern of my learned friend. I was under the impression that the heads had been filed and that he would answer my heads, which he hadn't had an opportunity to do, and then we'd go deal with it with the argument thereafter. That having set the tone by going through his heads, I believe that I'm obliged to do that. It might be that the cameras got the better of him, and that's why we're in this position, but so be it. What I want to...
Advocate Otis,
Yes, Worship.
it's an uncalled for statement.
As Worship pleases. Worship,
I mean-
I'm going to try my best to avoid those uncalled for statements, but I need to forewarn you, Worship, that issues were attributed to me that don't belong with me, and I don't take responsibility for them. He needs to, and I'll make it clear as we continue.
Sorry, I'm not being deliberate.
As we-
I just want to follow exactly that I understand it. May you just please repeat? You say,
Yes. Issues were attributed to me, Worship, that did not emanate from me, and for which I will be holding him accountable. It's as simple as that, Worship.
I hear what you are saying.
Thank you, Worship. So if I may begin then, Worship, it's human nature and logical that one makes a conclusion as to whether a person's guilty or not, and then in a judgment justifies that conclusion. That's why it's a common trend these days. We have it in the SCA and the Constitutional Court, where the order is given and then the ratio or the reasoning behind the order follows. So here, Your Worship, we have a similar position that one humanly and logically makes a conclusion and then justifies the conclusion with regard to the evidence, the probabilities and all other factors in taking a holistic view to the matter. Now there are two major issues that my learned friend might take offense with, but I need to put them up front and make myself clear. Firstly, Your Worship, we are of the view, with respect, that the charge sheet has been reverse engineered, for want of a better term, or adapted to suit the evidence, as I will show, Your Worship. And I heard what he said at the end, that his predecessor had utilized the term or euphemism and stroke or as a justification for his interpretation of the charge sheet. And I say, with respect, and I'll make it very clear in my argument, as I have that already done in my heads of argument, Your Worship, that this doesn't, with respect, cure the problem for the state. So the first issue, which is accepted as being my allegation against him, is that the charge sheet has been reverse engineered to suit the evidence that was led. I make that clearly in my head, and he's dealt with it. And his answer is that it's and or, and he used the phrase, he says, like bread and butter. Well, with respect, Your Worship, I can't give you a sandwich of bread and or butter, because if I give you bread and butter, it's got a particular meaning. Meaning if I give you bread or butter, there's no sandwich left. And that's what's going to happen to his charge sheet with respect. So he used the example now right at the end, and if you just have to apply it logically, Your Worship, to see it doesn't work. If I make an allegation, you can come to my restaurant, I'm going to give you a sandwich with bread and or butter, Sandwich implies it must be bread with butter. It cannot be the one without the other, and it cannot be the one to the exclusion of the other or in the alternative. And that's what's going to happen here. The second and most troubling, Your Worship, and let me put it up front so we can deal with it, is whilst addressing Your Worship, he said that I had come up with the concept of accused zero. Now, Your Worship, there's zero credibility to that allegation. It's a matter of logical fact, Your Worship, that he filed his heads of argument long before we did, and he refers to Larry Mavunda as accused zero. And I'm saying that there's no such concept in our law, in all my years of experience, and I even challenge Your Worship on this, to think of any matter Your Worship's heard of an accused zero. That's equivalent, Your Worship, to finding somebody in the gallery guilty of an offence that they haven't committed, and that's why I don't know where this concept comes from. I think it's absolutely foreign, and it's part and parcel of the reverse engineering to maintain that there was, in fact, such a position in our law or such a sustainable argument based on these facts. So those are my two major contentions, Your Worship, and I accept full responsibility for them, as he says, in my capacity as an officer of the court. I challenge anybody, Your Worship, with many, many years more than me of experience to explain the concept of accused zero. It's impossible with respect. It defies all logical explanation.
Advocate Horace, since you used the word, you challenged the court.
Yes.
I want to ask you the following, and then I stand corrected, and I will have to revert back to the record. But the concept of accused zero emanated from your client's evidence. So I assume that is where the state got it from. But the manner in which he refers to accused zero, well, that I will address at a later stage. But that is the only time I've ever heard of it. I fully agree with you.
Thank you. Thank you. But for the record, Your Worship, my client is a layman in the law.
Sorry?
For the record, my client is a layman when it comes to the law. My learned friend is not. So, Your Worship, if I may then begin. And what we say, Your Worship, and I will have regard to the exhibits in illustrating the point. We set out in the introduction, Your Worship, the charges that the two accused face. We distinguish between the two accused persons. And we say, accused one faces 5 of the counts, and accused 2 faces only 2 of the counts. The counts all relate to an incident at the Sisa Dukashi Stadium in Datsani, which we refer to as the stadium, within this court's jurisdiction, and we all know that the purpose why all the people were there, and it's estimated in the record, Your Worship, to be some 20,000 people, were to celebrate the EFF's 5th anniversary. And we set out the charges, Your Worship, with regard to the actual charge sheet. And I have it here, Your Worship, so there can be no doubt that I'm quoting it correctly. It's inexcusable to say I never drew up the charge sheet, therefore I'm not responsible for what it says, or my colleague drew it up and my colleague dealt with the further particulars, but I ran the trial. And I've checked it and I find no flaws in her approach. That, Your Worship, is uncalled for in a trial of this nature. So the charges are, firstly, accused one unlawfully possessed a firearm, and it's defined, Your Worship, to wit, a .223 Norinka rifle and stroke or a firearm, the make of which is unknown to the state without holding a license, permit or authorization. That is exactly how the charge sheet reads, Your Worship.
Yes.
Count 2 is accused one unlawfully possessed ammunition, to wit, and it's there, Your Worship, the article A. .223 Remington bullet, without holding a license, permit, dealer's license, manufacturer's license, goldsmith's license, import or export, or in-transit permit or authorization to do so. There's no and or that covers that situation with respect to Your Worship. It's there, and that's the charge that they were challenged to meet. And as he's just told Your Worship, a charge sheet enables an accused to prepare for the trial that they have to meet. So there we have it in count 2. It's specifically a .223 Remington bullet. Nothing about 9mm, and let me say it up front, or any other type of firearm or any other type of ammunition. It just doesn't exist there with respect to Your Worship. Count 3 was accused one unlawfully discharged a firearm, to wit, a .223 Norinka rifle and or a firearm, the make of which is unknown to the state, in a built-up area or any public place to wit the stadium. So let me pause at the end of all first three counts, Your Worship. They all refer to a firearm, not firearms in the plural. They say it's drawn, and it's meant to be drawn with precision. So it speaks of something in the singular being a firearm, a piece, an item of ammunition, or discharging a firearm, not firearms. And stroke or will never cure that with respect to Your Worship. It means one or the other. It's like a sandwich with bread and or butter isn't the answer, but you can have a sandwich with jam and or butter. It still has to have something inside it with respect to Your Worship, and that's using the illustration that my learned friend used just to show how clear it is. You still have to have a sandwich. Here you have to have an item once you put a vowel in the front. Then count 4. Accused 1 and 2 unlawfully failed to take reasonable precautions to avoid danger to personal property, and that the accused both had control of a loaded firearm. Once again, Your Worship, will see to it a, not several, a. .223 Narinka rifle and or a firearm, the make of which is unknown to the state in circumstances where it created a risk to the safety or property of the general public attending the celebration. Count 5, accused 1 recklessly endangered a person or property in that accused 1 unlawfully discharged or handled the firearm to wit a .223 Narinka rifle and or a firearm, the make of which is unknown to the state in a manner likely to injure or endanger the safety or property of the general public attending the celebration, residents of Mdantsane and the employees of Gear House, or with reckless disregard for the safety or property of the general public attending the celebration, the residents of Mdantsane and Gear House employees. And then finally, it's only for accused 2, provided a firearm or ammunition to any person not allowed to possess it. So if we look at the counts, Your Worship, it's quite clear that it refers to one specific set of conduct or one specific action. It doesn't refer to firearms or ammunitions that were. It speaks of only in the singular, to put it bluntly, Your Worship. We then set out the plea, Your Worship's well aware that they both gave not guilty pleas. Accused number 1 denied the allegations against him, put the state to the proof thereof, whereas accused 2 gave a detailed plea explanation in which he denied that he had handed a firearm or ammunition as alleged in the charge sheet, read with the further particulars to accused 1. That's what the record will reflect, Your Worship. Now, it doesn't help to some. I'm an officer of the court, and I would argue for the acquittal of the accused if I didn't prove the case. But at the same time, please find him guilty as an accessory after the fact. These are the specific details of the charge, and we all know, Your Worship, as Your Worship already asked, the further particulars amend the charge so as to enable the accused to meet the case that he has to meet. Now, in contradistinction to this, Your Worship, in my learned friend's heads of argument, he sets out the counts as follows in his paragraph 2. Count 1, unlawful possession of a firearm. Then he does dash. Rifle and, not and stroke or. He can't hide behind what his colleague says when he sets out the different case here. So count 1 is unlawful possession of a firearm dash rifle and unknown firearm accused 1 only. That's not the case with respect to Your Worship. The charge sheet speaks for itself. When we cannot say it's open to interpretation, that and stroke or means it wasn't just one firearm, it's 2 or 3 or several other firearms. But that's the case that he says was made out. Secondly, Your Worship, in count 2, he says unlawful possession of ammunition, and all of a sudden he goes away from the definition that's given there of the Remington ammunition. He says unlawful possession of ammunition, accused 1 only. Count 3 says discharge of a firearm in a public place or built up area or any public place, accused 1 only. Once again, a firearm. Count 4, failure to take reasonable precautions to avoid danger to personal property, accused 1 and 2. Count 5, reckless endangerment to personal property, accused 1. And his count 6 is providing a firearm or ammunition to any person not allowed to possess it, accused 2. So he's, with respect, changed the goalposts in his idea of what he set out to prove and what he tells the court that he set to prove when he drew his heads of argument up after the evidence had been led. So now, if we turn, Your Worship, to what we say here, the evidence, and we say, and I challenge him on this one, Your Worship, and it's not a personal attack in any way. There were 19 witnesses, not 18. Very little turns on the witness that he excluded, but the record will reflect that there were 19, not 18. I take no issue with that, Your Worship. But when we look at the testimony, and he makes this concession in his heads, when we deal with Colonel Nkwali. Colonel Nkwali says he had heard a loud noise. This is at the foot of page 3 of my head, Your Worship. But suspected that they were fireworks. He did not see accused one firing any shots on the date of the EFF celebration. He had been sent video footage that indicated that the accused one had fired shots with what appeared to be a rifle on stage. This resulted in him opening a case as the complainant, even though he had not received any report of any shooting taking place before, during, or after the event. That's conceded by him, Your Worship, in his paragraph 7.1. So if I can deal with both heads of argument at the same time. In 7.1 he says that he thought it was fireworks, and he explains that it turned out that it was shots, and that and that he didn't investigate it at the time, only once he had been shown the video footage. So we immediately ask ourselves one question, Your Worship. Did he report the matter, or is he also guilty, as my other friend would want you to hear, of being an accessory after the fact? Because he was there and he didn't really do anything until it went viral and everybody complained about it. And this is going to be repeated several times, Your Worship. The second witness, Your Worship, was Ntombekile Mankruma. Now it's interesting to see how we heard the same evidence but deal with it differently. He says, and I'm summarizing, Your Worship, in his paragraph 7.2, that she was a cleaner and she was cleaning the stadium after the birthday celebration had taken place, and found an empty cartridge case on the right side of the stadium, and now I'm quoting from his head, Your Worship, a few meters away from where the EFF stage was erected. Nothing could be further from the truth with respect to Your Worship. Few, and my learned friend is invited to look it up in the Oxford Dictionary, depicts 2 or 3, not 10, 20, 30, 40, 50 meters. It cannot be the case. And he goes further, Your Worship, because this becomes an important aspect of his heads of argument, where he invites Your Worship to have regard to the location where this cartridge was found and to draw inferences from it. And I invite and in fact beg Your Worship to do so, because that would lead to the acquittal of the accused. And he says here, Your Worship, in 7.2, that she then, Captain Swart visited the stadium on 1 August 2018 to interview the witness regarding the discovery of the spent cartridge case. She informed him that she gave the cartridge case to Wano, who is her supervisor. She had to point out the location where the cartridge was retrieved. Sergeant Nkululeko Tuzi took photos when she pointed the place where she found the cartridge case. This photo album was handed in an exhibit. It's very vanilla, Your Worship. We're told in the first paragraph, the witness says a few meters away. So in the first paragraph of this witness, she says a few meters away, and then she says, well, have a look at the photo album. Because this was put on record, and it was depicted perfectly. What we say, Your Worship, in our paragraph 4.2 is as follows: that this lady, being a cleaner, found a spent cartridge whilst cleaning the stadium after the celebration on 30 July 2018. She handed this cartridge to a supervisor and told her friend about it. Most significantly, and once again, Your Worship, I'll take you through the evidence like I did with the charge sheet. She pointed out the location where she had found the cartridge and was photographed doing so. And we take, Your Worship, into our confidence. And we say this photograph appears as photo 8 on exhibit A3, which is an area that is identifiable by a very high pole with lights above it on the far left-hand rear corner of the stadium, the area in front of which would have been covered by the white tent structure that appears on the photograph depicted in exhibit A. So now, Your Worship, I need to pause, because this is going to be the crux of the argument on inferences to be drawn. If we have regard, Your Worship, to what's was handed in by the state as Exhibit A. Photograph, Your Worship, which is very important. Your Worship will see there's the stadium as it was on the day in question. We have the light post that I'm referring to, Your Worship, as Your Worship looks at it on the left-hand side. And we have a white tent in front of that with structures alongside it. And then we say that was Exhibit A given in by the state. And we say to Your Worship, have a look at the photo 8 on Exhibit A3. Here we have, Your Worship, the telltale sign of where the actual cartridge was found. Photograph 8 on A3 has the witness herself pointing to a spot that is at 90 I'd say 45 degrees, I beg your pardon, from the pole, but in the vicinity of that large lamppost that we see in photo 7 and photo 8. Now, Your Worship, if one talks about drawing inferences from where it was found and how it was found, it's impossible for it to have been found or to find its way there on the night in question if it was fired as the state alleges. Because one has to interpret these pictures together, Your Worship, and look at the actual evidence to say, between the stage and that lamppost, as Your Worship I'll show now, there were structures. For a cartridge to get there was absolutely impossible, taking into account the ejectile range, its common cause of the firearm that the state alleges was utilized that night. So if we have a look at these two pictures together, and I'm going to ask Your Worship in due course several times to have regard to what I'm showing now, just to realize every time he says that it was found nearby or in the vicinity, nothing could be further from the truth with respect to Your Worship, because there's a large distance between where the stage was, where the lamppost is, and to where the witness is actually pointing out. We then, Your Worship, and I can summarize it very quickly, go through the rest of the evidence. There's Nomfundo Luana, the supervisor. We've got very little debate about that. We have the next one as Captain Swart. Your Worship will remember we visited and sealed. Then we have, we call it Jonathan Kumala, he calls it Jotin Kumala. We have Lieutenant Colonel David Johannes Janssen, and he explains that they were there. And he also explained, Colonel Janssen, that Larry Mavundla, and it's in both of our heads of argument, it's my paragraph 4.7, his paragraph 7.6, that Larry Mavundla was present and provided 2 further firearms for inspection, a 9mm P Glock pistol and a .223 Norinco rifle. An explanation that was given at the time, which was never disputed, was that although the firearms were not in East London on 28th of July 2018, the responsible person volunteered these firearms as well as all other firearms in his possession for ballistic testing. His statement annexes were handed in as Exhibit C. That's Lieutenant Colonel Janssen. He gives that explanation. So we know that they knew the explanation, and we know that he'd encountered this Larry Mavundla, who develops into accused 0. So now you've got Larry Mavundla, Your Worship, who features prominently from the outset of the investigations. And my question is a rhetorical one, because it remains unanswered, Your Worship, is what do we make of the state's failure to either charge or call this Larry Mavundla to testify? Would the court be entitled to draw a negative inference? My submission, yes, definitely. Can the court infer any facts or attribute any facts to Larry Mavundla, having not called him, having had him being referred to as accused 0? My answer, Your Worship, is that is a fundamental flaw with respect in the state's case. And they were fully aware of it, and my learned friend goes further. He says, I looked at this case when I took it over from our predecessor. He's giving evidence now, but he says, and I was satisfied there's a solid case, and I accepted that there was perfect, there were no flaws in the case. That's what he said, and now we look at this, Your Worship, we say, but isn't this in itself an absolutely fundamental flaw in that Larry Mavundla was referred to from the outset, is placed on the stage, was there with all the other police officers, was the registered owner of the two firearms that he relies upon in his argument, but yet was never ever called to testify. We then both have Warrant Officer Becker. And then we both then have Colonel Mandisi Mgwadleka. Now, it's important, Your Worship, that I stop on Colonel Mgwadleka, because my learned friend, in his heads of argument, explains the rifles, and he says that the Colonel concluded that the breech face extractor and ejector do not correspond with the rest of the serial numbers on the firearm, and concluded it was changed to affect the outcome of the ballistic tests. He said that he was going to show Your Worship that that was admitted, but he hasn't given you the page reference, even though he said that he would. He also goes further, Your Worship, in his heads of argument at paragraph 7.9 at page 6, and he says that Mgwadleka confirmed that the markings that are made on the cartridge case by the firing pin, breech face, extractor and ejector were negative, as these parts form part of breech block that were removed after the shots were fired, but before the firearms were sent to the ballistic unit for tests. Now that, with respect, is not my recollection of his testimony. As I understood, he said there's nothing sinister to be drawn from the fact that this had been changed. And it does happen that in the process of cleaning firearms, they're often exchanged and they fit in interchangeably. I don't, with respect, believe that he said that, but that doesn't affect my argument in much. But I just want to put the record straight, if I may. We both then referred to Ashley Singh, and he calls them the Gearhouse witnesses, and I have a very similar summation of what he says about the Gearhouse witnesses. It's important that he notes that even at the stage of the Gearhouse witnesses, it was put to them and they conceded that they were unable to dispute whether the firearms were real or blank or toy firearms. That's at the foot of his paragraph 7.10. And we then deal with Samuel Ntandazo Kwata, also from Gearhouse, and Captain Mzuku. Then there's Dwayne Francis, who did the digital investigation. And then we say there was another witness. He also said there's a Captain Sorol Jacobus Kruger, who testified. We just have them in a different order, but they're there. There's Warrant Officer Amanda Yvonne Steenkamp, Captain Rian Buerter, and Captain Govender, who we make an error in referring to as a male when it was a woman. He also makes a similar error. He talks of her once as a male and once as a female. And then there's the Colonel Swartboy, who is the final person. The only witness that we say he forgot in his summation, as I said, very little turns on it, Your Worship, is we identified Captain Sorol Jacobus Kruger, who received 3 batches of firearms. Nothing turns on it, it was just in the testing process. I do not make anything of that, Your Worship. It's an absolutely innocent oversight. Now, what's important, Your Worship, and what I need to elaborate on, if I may, is in paragraph 4.19. We highlighted this, and Your Worship has heard this argument, but I need to explain it. And that's Captain, Colonel Swartboy deposed to 23 statements. He could not say whether the firearm seen in the video footage was a real firearm or a staged or blank firearm. But importantly, Your Worship, and it was he that confirmed this, because he was the investigating officer. He confirmed that 5 members of the SAPS VIP protection unit were present, and they deposed to statements. These statements were handed in as exhibits, but he did not make mention of any one of them seeing accused, but did not make any mention of any one of them seeing accused when firing a firearm. Why it's important, Your Worship, is he was the investigating officer. He was in charge of the docket. He'd made all these statements. He was aware, not personally involved in, but aware of these statements that were put to him when he testified, and he confirmed them. They're before the court as exhibits, and that's what's important, Your Worship. So you have now, with respect, at least 5 police officers that were on the stage, identifiable on video according to my learned friend, but were never charged as having facilitated a dangerous situation or failed to report a crime or being accessories after the fact, or even worse, Your Worship, let me say it so that it's out there, having committed perjury, and that they were there, they saw a firearm being fired, and then deposed the affidavit saying, I never saw it, if they're in the immediate vicinity. So these are the gaps with respect that are there in the state's case. And whilst my learned friend brushes over it, another pertinent gap with respect to worship is, and it's our paragraph 5. Notably, the state was permitted to play video footage that have been spread on social media and gone viral. We refer to it as the viral footage, as well as the video footage that have been recorded by the above detailed employees of Gearhouse. We refer to that as the Gearhouse footage. The viral footage depicted the shooting, but the Gearhouse footage did not. These were accepted as exhibits by this Honourable Court. It subsequently became apparent from cross-examination that the authenticity of the viral footage had not been established, so we say that that was never established, and the laptop on which the original Gearhouse footage had been captured had been stolen. So now we have a situation, Your Worship, and it's something that the court will be required to rule on, where we have two sets of video footage. The one we have no author of, or no origin of. That's the viral one. Nobody's come and said that was my cell phone that sent that video footage. I took it. This is where I was. This is what I saw. And the authenticity was placed in dispute. Has never been proven. The other, Your Worship is well aware, was on a laptop that had been stolen. So the original's missing. So it's a situation, Your Worship, where once again we have a gap in this regard. Now, my learned friend for accused number 2 has set out the different tests to be applied. My learned friend chooses the easier one for the state. That is, if it's relevant, it's admissible. It doesn't have to be the authenticity, etc. Doesn't be proven. There are cases that go either way, Your Worship, out of fairness. Your Worship made a ruling at the time that it could be played, but we, at the end of the case now, Your Worship, and we haven't been able to establish the authenticity or reliability of those two videos with respect. The one lacks the actual author. We don't know who was the creator of that video. The other one, the original laptop, has been stolen on everybody's version. We then set out in our heads of argument, Your Worship, the section 174 applications, and I need with respect to repeat that because the test now is proof beyond reasonable doubt, not just whether there's a case upon which the accused ought to provide an answer, in that there's a prima facie case. And we had submitted at the time on behalf of accused number 1, firstly, not one of the many eyewitnesses at the celebration complained of any firearm being discharged. So you have a situation, Your Worship, in summary, where you have 20,000 people in a gathering, at least 5 of whom are VIP protection officers and others. You have other policemen present, you have a whole host of people present, and not one single eyewitness who attended the event has complained of a firearm actually being discharged. Secondly, not one of the many eyewitnesses at the celebration had complained of any fear or danger due to a firearm being discharged. So nobody said that their life was in danger, or they were at risk, or they felt threatened, or that there's any danger whatsoever, which is part of the charge against the accused, endangerment. Thirdly, not one of the many eyewitnesses to the celebration had run for cover during the celebration in fear for their life or property. Now, it's all very well, my learned friend says, look at the video, look carefully, look in the corner, at the extreme left-hand side, you'll see people moving away. Your Worship, that could be, they're moving to go to the toilet, they're moving to buy a bread and butter sandwich, they could be moving for any reason whatsoever. But you cannot draw the inference with respect that they're running out of fear, having not called one of them to testify. And then we say in paragraph 7.4, in fact, and most startlingly, not one attendee from the many people who had attended the celebration was called to testify as an eyewitness. Fifthly, additionally, there had been 5 SAPS VIP Protection Services members on the stage at the celebration in the stadium, and not one of them had seen or complained of any firearm being discharged. Sixthly, these 5 SAPS VIP Protection Services members had been traced and had made statements, but not one of them had mentioned anything untoward having happened at the celebration at the stadium. So not only do we hear that a firearm was fired. Police were on the stage, but they actually traced and they called to make a statement. Not one of them claims to have seen this firearm being fired or having feared anything or being scared of anybody. Seventhly, the place where the spent cartridge had been found would have been beneath structures that had been there at the time of the celebration, which made it impossible for it to have been fired from a firearm during the celebration, as the structures had been penetrated and damaged, but they had not. That's the photographs that I showed you, Worship. Eighthly, it was not possible to say when the spent cartridge had been placed there. Ninthly, it was not possible for the spent cartridge to have been ejected from a firearm on the stage at the celebration and land where it was found. And finally, Worship, there were no touch DNA traces or fingerprints to link accused one to the suspected firearm or the spent cartridge. We then say it was further submitted on behalf of accused one that the clearest indication of the deficiencies in the state's case were evident from the testimony of the investigating officer, Colonel Swartboy, who had fully investigated every aspect of this matter, been in charge of the investigation, deposed to 23 statements and testified in chief inter alia that, firstly, he had been assigned to investigate the alleged shooting at the celebration. Second, he had requested permission to interview employees and staff on duty at the time of the celebration. Thirdly, the purpose of the interviews was to establish whether they knew about the incident and to gather information about the incident. Fourthly, the scene had been reconstructed by Sergeant, subsequently Warrant Officer Becker, to ascertain where the spent cartridge had been picked up. Fifthly, he had received a copy of the viral footage that depicted accused one firing shots with, as he described, what appeared to be a firearm. Sixthly, a CD was made of the viral video footage and it was sealed in a forensic bag. Seventhly, accused 1 and 2 had been identified as having been on the stage at the celebration. Eighth, a search warrant was applied for and obtained to ascertain whether accused 2 had rifles in his possession that could fire that cartridge casing. Ninthly, accused 2 cooperated fully and assisted throughout the process. Tenthly, rifles were received in 3 batches and tested. 11thly, he was not a ballistic expert but could clearly see muzzle flash when accused one fired, as viewed on the viral video footage. 12th, one can see where the shots are being fired on the side of the stage and during the reconstruction at more or less the same area where the cartridge was found, as pointed out by the witness. And finally, the recovery of the further footage was just a confirmation of the incident together with the viral footage that was circulated. Under cross-examination, Colonel Swartboy made the following concessions. Firstly, he had not of his own accord mentioned the 5 VIP Protection Services members of the SAPS that had been on the stage at the celebration. Secondly, he had seen the statements of these officers and they had stated therein that they had not seen any shots being fired by accused one. Thirdly, had they seen a crime being committed in their presence, they were obliged to have reported this but had not done so. Fourthly, there was no connection by means of DNA or fingerprints between accused one and the suspected firearm. Fifthly, there was no connection by means of DNA or fingerprints between accused one and the spent cartridge. Sixthly, he had not searched accused one's home or workplace for any such firearm. 7, no powder residue tests were conducted on the suspected firearm. 8, no eyewitnesses complained about any conduct at the celebration. 9, no eyewitnesses have been called to testify. 10th, he had not traced the photographer of the viral video footage. 11th, the chain of custody of the viral footage only began when the CD was created. 12th, he was unaware of the viral footage having been downloaded onto an external hard drive. 13th, the viral footage had never been authenticated and manipulation of it could not be excluded. 14th, the item that he had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. 15th, there had not been a reconstruction of the scene but merely a pointing out. 16th, he could not explain how the spent cartridge could have ended up where it was found. 17th, the cells and equipment had been thoroughly examined and no damage was found. 18th, he could not say whether a stage gun or blank gun had been used. And finally, he could not deny that a stage gun or blank gun emits muzzle flash. Now, I pause to add here, Your Worship, that it was clear that it was put to all of the witnesses that the accused defense was that this was a stage gun or a blank gun. Not one of them requested sight of it. Not the experts that my learned friend says were entitled to see it. Not one said, well, let me see, let me test and let me see what the case is. But it had been put from the outset, and there were security concerns, and Your Worship is well aware of it, to bring what eventually came to court when he testified through to the court. Paragraph 10. We believe that the accused was entitled to a discharge at the close of the case, and this is where we go back to the charges, Your Worship, and make our case clear. The state had not led any evidence to show that accused one possessed or shot a .223 Norinco rifle and or a firearm, the make of which is unknown to the state, without holding a license, permit or authorization. Secondly, the state had not led any evidence to show that accused one unlawfully possessed ammunition, to it a .223 Remington bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or in-transit permit or authorization to do so. Thirdly, the state had not led any evidence to show that accused one unlawfully discharged a firearm, to wit, a .223 Norinco rifle and or a firearm the make of which is unknown to the state, in a built-up area or any public area, to wit the stadium. Fourthly, the state had not led any evidence to show that accused one unlawfully failed to take reasonable precautions to avoid danger to personal property, and that accused one had control of a loaded firearm, to wit, a .223 Norinco rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the celebration. And finally, the state had not led any evidence to show that accused one recklessly endangered a person or property, and that accused one unlawfully discharged or handled a firearm, to wit, a .223 Norinco rifle and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the celebration, residents of Ndantani and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the celebration, the residents of Ndantani and Gear House employees. So we say most significantly, the accused one was not required to give evidence to supplement the state's case. Now, it's important, Your Worship, that I pause there to point out that you won't find any mention of a Glock 9mm that the state now relies upon in their submissions to Your Worship. And we record in paragraph 12 that the section 170 applications of both accused were refused, and that Your Worship delivered a judgment. And then we deal with the judgment, Your Worship. And it's important that I set out the basis, because this then sets out the case that the accused had to meet. It's in paragraph 13. Your Worship listed the witnesses that had testified and summarized their evidence. Thereafter, Your Worship addressed the issues raised in the heads of argument on behalf of accused one. In response to that, Your Worship held that even though the Gear House footage did not depict the shooting, this was cured by the evidence of the Gear House witnesses, who testified in court that they saw it afterwards but not during the event. Secondly, none of the eyewitnesses having complained come forward, run for cover, feared for their lives or property, or even testified was not relevant at that stage, but may be relevant at some point in time because they do not form part of the elements of the crimes faced by accused one. Thirdly, the 5 SAPS VIP Protection Service members who have not seen anything was also an issue that was not appropriate to raise at that time because Colonel Swartboy had only been confronted with this aspect during cross-examination. In fairness, could not answer regarding the contents of these statements because they had not been obtained by him, and these 5 witnesses had not given evidence before the court, so the court did not have a full picture of what took place as to where they were. Only they could tell, and why they were not called had left the magistrate wondering since the day she had heard so. That remains the case still today, Your Worship, with respect. Sub 4, in relation to where the cartridge had been found, which would have been underneath structures that had been there at the time of the celebrations, which then made it impossible for it to have been fired from a firearm during the celebration unless it had been penetrated and damaged, unless it had penetrated and damaged these structures. The state did not allege that the place where the cartridge had been found was the exact spot where it had been ejected. Fifthly, it was not possible to say when the spent cartridge had been placed where it had been found. It was common cause that the ejection range was 1.5 meters and 2.5 meters to the right and to the back. Sixthly, the absence of DNA or fingerprints on the cartridge was explained as that she would have been surprised if there were in fact fingerprints or DNA after some time. Seventhly, Colonel Swartboy explained that there were indeed aspects that had been concerning, and he had accepted this during cross-examination but could not clarify this under re-examination. Eighthly, Colonel Swartboy had indeed confirmed that he had seen the statements by the 5 protectors, but the contents thereof were still not before the court. He confirmed that if they had seen a crime being committed, they were duty bound to report it. Ninthly, the photographer of the viral footage had not been traced, nor had the source thereof, and the chain of custody only began when the CD was created. Tenthly, the item that Colonel Swartboy had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. 11thly, Colonel Swartboy could not deny that a stage gun or a blank gun may emit muzzle flash. 12thly, most notably, the submission that the state had not led evidence that accused 1 had fired a .223 Norinco firearm was not correct. And 13thly, most certainly, the court agrees that accused 1 is not required to give evidence to supplement the state's case. Then, in relation to accused 2, Your Worship held that much emphasis was placed on the fact that none of the videos or witnesses testified that they saw him handing a firearm to accused 1, but that is not the charge. The charge was unlawfully supplying or in any other manner giving possession of a firearm or ammunition, being the Norinco firearm and a Remington bullet. Paragraph 15. The court thus held that the evidence so far presented by the state required them to testify because a mere say-so that it was a movie gun does not make it so. It is not evidence. A mere say-so in light of the evidence that has been presented so far, I'm not saying which has been accepted as fact, but which has been led, I think it's led so far. Nevertheless, the state has to date not answered these issues that were raised on behalf of accused 1 and 2. So we say we're now at the end of the state's case. We are now at the end of the defense case. The onus moves to proof beyond reasonable doubt, and these troubling features still permeate every permutation of the evidence led thus far. We then explain what happened in the defense cases, and we say it was agreed between accused 1 and 2 that accused 2 would present his case first. Accused 2 called the following witnesses to testify on his behalf. First, Mr. Martin John Hood, an attorney who specialized in aspects relating to the Firearm Controls Act 60 of 2000, and it played an instrumental role in the drafting of the Act. And this is the important part that my learned friend doesn't seem to have dealt with in his heads of argument or his oral argument to Your Worship, because the important aspect of Mr. Hood's evidence as far as we were concerned is that he had assisted Tactical Security Services, TSS, to obtain its firearm licenses for their guards. And he identified the responsible person within TSS to be Clement and Luli. He had held this position since 13 March 2018. So what we say, Your Worship, is that goes against what my friend argues, that at some stage accused number 2 was an owner of the business, therefore he had an obligation, and therefore is guilty as an accessory after the fact. We say that's not the case. The responsible person for those firearms, as per the licenses, on the undisputed testimony of Mr. Hood, was this Mr. Clement and Luli. And we say that he further said that, this is Mr. Hood, he explained that no license was required for a blank gun, even though they looked very similar to real firearms. He further referred to a document from Advocate Rodney de Kock of the NDPP, notifying the police that no prosecution should take place in respect of these firearms. These documents in an email were accepted as exhibits L1 and L2. They're before Your Worship. The second defense witness called by accused number 2 was Johann Christoffel de Klerk, a ballistics expert who explained his background and qualifications. He distinguished between class characteristics, subclass characteristics, and individual characteristics relating to the comparison of marks on fired cartridges. He further explained that blank guns looked the same as rifles and that the ejection range of ammunition fired from a Norinco rifle was backwards and to the right within a 2-meter radius. So he extended a bit further than was previously the case, but it's still within that same range. Thereafter, the case for accused 2 was closed. Then accused 1 testified in his own defense and stated inter alia that he had utilized a stage gun that looked like a rifle. Now, Your Worship, let's pause here and accept my learned friend's invitation to draw inferences. So now we're not just dealing with the say-so, as Your Worship referred to it in cross-examination, but the actual under-oath testimony of the accused person. And the challenge, Your Worship, is there's nothing to disprove his version. If, by way of example, Your Worship, there had been some damage caused by a bullet nearby, then one could say he's lying because there is damage. Look what happened here. It's not the case. If the police, Your Worship, were on the stage had said there was a real gun, he's lying, then there'd be something to contradict it. If somebody else had found all these spent cartridges that my learned friend speaks of, or somebody had seen anybody picking up the spent cartridges, because now The state's version we heard today, 26 shots were fired. So yet again, another rhetorical question is going to be, well, what happened to the spent cartridges? Why is there only one when 26 shots were fired? He argues that somehow, which we don't see on video, but the inference that he asks you to draw is that accused number 2 picked up those spent cartridges. There is no evidence, not oral, not alleged, not video, of him doing so. There's no evidence of accused number 1 picking them up. He goes even further. He says there's no evidence that blank firearms, and I'll show you the quote, Your Worship, emit spent cartridges. There's no evidence to the contrary either, Your Worship. It just was never canvassed. So one spent cartridge found at a large distance under where previous structures existed with respect doesn't cure or contradict the testimony of accused number 1 when he says, I used a stage gun that looked like a rifle. One cannot say, looking at all the inferences, where it was found, when it was found, what it is, how it's traced back with possible identificatory features of being a Remington spent cartridge, etc., that would fit into a Narinka rifle. I therefore can conclude that this is the actual cartridge that came out of that firearm for all of those reasons, because it's not the case. It goes against all the other objective facts. And he says, don't just look at Rex versus Blom, look at the other cases that say, look at the conspectus of all the evidence. And if we look at the conspectus of all the evidence, then one cannot contradict that which he testified to under oath. Second, he identified such a stage gun and handed it to Your Worship and the state to see the extent to which it looked like and felt like a real rifle. Thirdly, he further explained his personal security arrangements and how his close protectors operated. He even identified them by name and subsequently pointed them out under cross-examination when the video footage was played. Fourthly, the contents of the statements was put to him and he explained that they deposed to statements at the request of the state, not the defense. Nevertheless, they were not called by the state to testify. Fifthly, he further explained that he had brought a toy gun that he had received from the EFF Secretary General's office that had belonged to the EFF. Sixthly, he further explained that Larry Mavunda had handed it to him because it was his job to bring it there and carry it. Seventhly, he further confirmed that Larry Mavunda was present in court but refused to identify him. Eighthly, he refused to answer questions relating to a handgun because he had not faced any such charge and had prepared his defense on the charges defined by the magistrate as relating to a Narinka firearm and the Remington bullet. Ninthly, he was shown the video footage in slow motion and denied that anybody had run away in fear. Instead, he had seen people walking around and doing different things. They could not say what they appeared to be scared. In fact, they seemed to be cheering. Finally, he had never been approached to explain what firearm he had used and could have provided the blank gun for testing if he had been requested to do so. We then turn, Your Worship, to the state's heads of argument. I've dealt with some of these issues, but let's please go through them in the light of my learned friend's latest argument. We record here, and the date's important, Your Worship, that the state filed heads of argument on 12 August 2024. In those heads, the state has intentionally misconstrued the charges levelled against the accused. It now identifies the charges, and we quote from their own heads of argument, but our emphasis, Your Worship, says count 1, unlawful possession of a firearm, rifle, then in bold, and unknown firearm, accused 1 only. Count 2, unlawful possession of ammunition, accused 1 only. Count 3, discharge of a firearm in a public place or built-up area in any public place, accused 1. Count 4, failure to take reasonable precautions to avoid danger to personal property, accused 1 and 2. Count 5, reckless endangerment to personal property, accused 1 only. Count 6, providing a firearm or ammunition to any person not allowed to possess it, accused 2 only. And we say the adaptation of the charge sheet was done with the intention of attempting to adjust the charge sheet to match the evidence. This is what I referred to earlier, Worship, as reverse engineering. And we quote the original charge sheet, Worship, which I've quoted. I'll try to summarize it. Count 1 identified the firearm that was alleged to have been in accused one's possession as being a .233 Narinka rifle and or a firearm, the make of the firearm unknown to the state, without holding a license, permit or authorization issued in terms of the Firearms Control Act to possess that firearm. There is clearly an identification of the firearm that was alleged to have been possessed by accused one as being a .223 Narinka rifle, and there's reference to only one particular firearm. Count 2. Identified the ammunition that was alleged to have been in accused one's possession as being, and we quote, 1.223 Remington bullet. Without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import, export, or in-transit permit, issued in terms of the Act or otherwise authorized to do so, there is clearly an identification of the ammunition that was alleged to have been possessed by accused one as being a .233 Remington bullet, and there's reference to only one particular bullet. Count 3 identified the firearm that was alleged to have been discharged by accused one as being a .233 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, in a built-up area or any public place, to wit the Sisa Dukazi Stadium in Dansani, without good reason to do so. There is clearly an identification of the firearm that was alleged to have been discharged by accused one as being a .233 Narinka rifle, and there's reference to only one particular firearm. Additionally, the location where this is alleged to have occurred is identified as being at Sisa Dukazi Stadium in Dansani. Count 4 identified the loaded firearm that was alleged to have been under the control of accused 1 and 2 as being a .23 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the 5th Economic Freedom Fighter celebration and unlawfully failed to take precautions to avoid the danger. There is clearly an identification of the loaded firearm that was alleged to have been under the control of accused 1 and 2 as being a .233 Narinka rifle. There's reference to the general public attending the 5th Economic Freedom Fighter celebration. Count 5 identified the discharged or otherwise handled firearm that was alleged to have been discharged or otherwise handled by accused one as being a .233 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the 5th Economic Freedom Fighter celebration, residents of Mdansani and the employees of Gearhouse, or with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighter celebration, the residents of Mdansani and Gearhouse employees. Count 6 identified the firearm that was alleged to have been supplied or in any other manner the possession of which was passed and the ammunition as being a .233 Narinka rifle and or a firearm, the maker of the firearm unknown to the state, and a .223 Remington bullet. And the person to whom they were given was identified as being Julius Malema, being a person who is not allowed in terms of this act to possess that firearm and the ammunition. So we say there is clearly an identification of the firearm and the ammunition that was alleged to have been supplied by accused 2 as being a .223 Narinka rifle and the ammunition as being a .223 Remington bullet. Additionally, the person to whom accused 2 is alleged to have supplied the firearm is identified as being accused 1. And the allegation was made that he was not allowed in terms of the Firearms Control Act to possess that firearm and or ammunition. In paragraph 22 we say this intentional adaptation of the charges levelled against both accused cannot be regarded as being a bona fide error. The adaptations were made in an attempt to change the charge sheet to match the evidence that was led and to cover for some of the gaps that became evident in the state's case. The accused, in paragraph 23, both had a constitutionally recognized fundamental right to know the case they had to meet and to prepare the defences accordingly. My learned friend has conceded that today, Your Worship. Additionally, the magistrate had a duty to inform both accused what evidence was admissible against them before they presented their defence cases. We refer in regard to my learned friend's duty to section 35 of the Constitution, and for the issue relating to the admissible evidence to state this isn't law, which is in a footnote, Your Worship. We then say any attempt to now argue that the charge sheet referred to more than one firearm or more than one bullet would be prejudicial and unconstitutional. Only one firearm was referred to in the evidence of the state witnesses. This firearm was identified by them as resembling a rifle. That would be compatible with the description of it being a .223 Narinka rifle. Similarly, there is only reference to one spent cartridge in the charge sheet and the evidence of the state witnesses. This spent cartridge was identified in the charge sheet and the evidence as being a .223 Remington bullet. The adaptation by the state at this late stage is indicative of its acknowledgement that the evidence led to during the trial did not accord with the allegations in the charge sheet. This issue was alluded to by accused one who has been cross-examined by the state. He stated that he had only been charged with the possession of one particular firearm and one particular bullet. Consequently, he had prepared his defence in this trial on the basis of only those allegations, as he was constitutionally entitled to do. These allegations are further borne out by the recently introduced allegation by the state in its heads of argument that a video went viral where an accused one was seen firing 15 shots with a handgun, followed by an additional 7 shots with a rifle. Another clear illustration of this adaptation of the allegations against the accused is the allegation in the state's heads of argument that accused 2 is then seen approaching accused 1 after he fired the shots. Thereafter, accused 1 joined the delegates on the stage and was no longer in possession of the rifle. There can be no doubt of the clear adaptation of the allegations by virtue of the concession made by the state when it submitted. The state has not proved its case beyond reasonable doubt whether accused 2 handed the SPA 249-14 rifle to accused 1. The submission is made after proper consideration of the evidence of the third video, viral footage, coupled with the submission made in the state's further particulars, wherein it was alleged that accused 2 handed the rifle to accused 1. The video footage is inconclusive in this regard. The state has further attempted to adapt the case that it sought to make out against the accused, and it submitted that accused 2 would have been guilty of an offence in terms of section 120 sub 10 sub A if it proved that he had handed the firearm to accused 1 to commit an offence. In a further clearly prejudicial surprise move, the state has subsequently, for the first time, drawn the attention of this Honourable Court to the provisions of section 257 of the Criminal Procedure Act on the basis that if this Honourable Court is not in accord with the state's assessment of the evidence insofar as accused 2 is concerned, the view to encouraging this Honourable Court to convict accused 2 as an accessory after the offence. There is no justification for the state's conduct and submissions in this regard. When the witnesses, including but not limited to Mr. Hood and accused 1, testified, no such permutation or allegation was put to them. In fact, insofar as the state now seeks to contend that accused 2 facilitated the commission of an offence by accused 1, it was obliged to put that allegation to him in cross-examination but did not do so. More disturbingly, the state now submits that accused 2 had the breech block and or facilitated the removal of the breech block of the SPA 249-14 rifle to affect the outcome of the ballistic test results. We give the quote, it's paragraph 19 of the state's heads, Your Worship. This was not put to any of the witnesses, including but not limited to both the state's and the defence ballistics experts. It is also not supported by any of the evidence led in the trial before this Honourable Court. Similarly, the submission that this toy blank rifle was the basis of accused 1's defence, and one would have expected that it should be produced to the ballistic expert or experts to compare it to the video footages and give an expert opinion on this aspect. In my view, the evidence relating to the actual blank toy rifle and the timing of presenting such evidence does not bolster the accused's defence, nor does it take his case anywhere. It is not only speculative, this is our submission, Your Worship, after the quote, from the heads at paragraph 29, we say it's not only speculative, but also lacks substance because the state's ballistics expert was confronted with the characteristics of such a firearm and could not dispute that it emits muzzle flash when fired. Dealing still with the heads of argument and the evaluation by my learned friend of accused 1's evidence, we say that this is unsubstantiated and we set out our reasons. Firstly, there is no substance to the allegation that he lied about seeing people running after he fired the shots, despite this factor being so obvious as people could clearly be seen running in the first video footage when he started to discharge the 9mm Glock P handgun. Secondly, there is no evidence of a 9mm Glock P handgun having been at the stadium in the possession of accused 1 or even having been discharged. Thirdly, no spent cartridges from such a firearm were found at the scene, and no damage consistent with the firing of such a firearm on numerous occasions at the scene could be found. Fourthly, in fact, it was never put to anybody who testified that such a firearm had been at the scene in the possession of accused 1 or fired by accused 1. We say in paragraph 37, in the circumstances, the allegation that accused 1 was evasive and prepared to adapt his evidence as anticipated the state's cross-examination has no substance and ought to be regarded as being more indicative of the state's conduct in this matter. The state has obviously adapted the allegations against both accused with a view to adjusting it to be consistent with the evidence led in this matter. Similarly, the allegation that accused 1 knew that these were real firearms and that firing it into the crowd would pose a serious danger to lives and limbs if fired directly into the crowd is totally irreconcilable with the objective fact that no cartridges were found in the vicinity of where he was alleged to have fired these firearms and no damage could be found. Another instance of not having put allegations to accused one relates to the submission that the person that handed the firearm to accused one took it from him again after he fired the shots and pressed the slide release as the slide remained backwards when the magazine was empty, and was compelled to ensure that the slide of the firearm moved forward to its original position before he could place the firearm as his back where he originally took the firearm from before accused one fired the shots. And that's a quote, Your Worship, from the State's Heads at paragraph 32.14. This was never put to any of the witnesses who testified, including but not limited to the ballistic experts and accused one. We say regard being had to all of the circumstances and objective facts, it cannot be contended by the State that the evidence clearly indicates that both firearms discharged were real firearms, and the court should make such a finding. And that's a quote from 32.15 of the State's Heads. The further reference to accused 0 is nonsensical. So far as the State might wish to infer that this is a reference to Larry Mavundla, the State should provide an explanation for its failure to either call this person to testify or to have charged him for the allegation that it purports to level against accused 2. The State did not even attempt to obtain a statement from Larry Mavundla. The State's belated attempt to refer to him as accused 0 is the clearest acknowledgement of the significant role that he played, and its inexplicable failure to have approached him by virtue of this reference to him as accused 0. One wonders whether the State would not like him to have been convicted without having been tried. The most astounding submission made by the State goes to the crux of how this Honourable Court is obliged to assess the evidence that was led before it, is that the timeline regarding when and where the cartridge case was discovered, as well as the proximity of its discovery in relation to the stage, is an important aspect to consider. Due regard being had to these factors, being the time and place of discovery of the spent cartridge case, it cannot be said that there is no doubt that it was fired by accused 1 on the stage on 28 July 2018. Both the time and place of its discovery militates against a guilty verdict beyond reasonable doubt. Your Worship, we say that with regard to the photos that I showed Your Worship earlier, Exhibit A and A3, photo number 8, seen in the context of photo number 7, and the fact, Your Worship, that there's nothing that would corroborate that. There was no powder residue test done of the accused or of his clothing or anything in that regard. We say the objective evidence and judgment by the magistrate in the Section 100 application make it clear that it has not been proved beyond a reasonable doubt that that cartridge was fired by accused 1 on 28 July 2018. This is exacerbated by the State's further contention that several shots were fired by accused 1 from 2 different caliber firearms at approximately 2000 hours the Saturday evening of 28 July 2018. It's a quote from paragraph 32.24 of his Heads of Argument. So surely one would have expected there to have been damage, if not injuries, and numerous spent cartridges at the site. Notably, there was no evidence by any eyewitnesses of any shooting. More significantly, there was no evidence by any eyewitness of anybody removing any spent cartridges that one would expect to have been there if accused 1 had fired several shots from 2 different caliber firearms as contended by the State. The ridiculousness of the State's submission in this regard is further borne out by its contention that the spent cartridge case was found on the right-hand side of the stadium in close proximity, and we added to where the stage was erected, which incidentally is the same direction accused 1 fired the shots. And we say, as I showed earlier, one only has to have regard to Exhibit A as viewed with photo 8 of Exhibit A3 together with the undisputed ejectile range of a Norinco rifle to dispel this myth. The maximum range can be doubled, tripled, or even quadrupled, but one will not be able to arrive at the conclusion that the State is attempting to convince this Honourable Court to make. Additionally, one would not only have expected to find injury or damage, but also numerous spent cartridges far closer to the stage, and not just one cartridge that inexplicably was found where structures had stood at the time. In fact, there is no evidence to prove that the cartridge that was handed in was actually fired on 28 July 2018. There are numerous explanations and hypotheses that can be put forward for it having been found there, but none to the exclusion of all others. To thus contend that accused 1 was the only person who fired shots on 28 July 2018 as being the sole explanation for the finding of the spent cartridge by the clean on 30 July 2018 is not sustainable. Additionally, to reject accused 1's version that he had fired the blank firearm on the basis of the spent cartridge having been found on 30 July 2018 is similarly unsustainable. To require accused one to provide a plausible explanation how the spent cartridge was discovered at the very stadium where he fired shots, other than to state that he does not know or that it could have been planted before he arrived at the stadium or when he left the stadium, is not only an unfair submission and constitutes unfair cross-examination, but does not take the case any further, make out a case of proof beyond reasonable doubt. These are quotes from the heads, Your Worship, that we deem it, they're identified in the footnotes. While it is submitted that this Honourable Court is not obliged to indulge in conjecture and find an answer to every possible inference which ingenuity may suggest, any more than the Court is called to seek speculative explanations for conduct for which on the face of it is incriminating, there is no legal substance to such a submission. In a similar vein, it cannot be said that once the video footage, which it is pointed out the authorship of which has not been claimed or attributed to anybody, went viral, nobody could have planted the spent cartridge at the stadium. Because Malema and friend had argued that in order to have done that, somebody had to have planted it there knowing that this was going to go viral, but the one doesn't necessarily go before the other. It's not a logical conclusion. This Honourable Court is reminded the video footage the State refers to as the silent witness has never been proven. The objective facts are that nobody has claimed to have been the photographer of the video footage, the owner of that cellular phone has not been traced, and the laptop that was utilised by Gias was stolen and never recovered. Thus, the authenticity of the video has never been established beyond reasonable doubt. In actual fact, all of the real evidence referred to as the greatest stumbling blocks in accused one's defence that tips the scale in the State's favour are not accurately recorded in that. Let me pause here, Your Worship, to say that one can't speak of tipping the scales when proof beyond reasonable doubt is required. It's not a preponderance or a balance of probabilities. So firstly, despite the undisputed presence of thousands of people at the EFF celebration, there were no eyewitnesses who testified before this Honourable Court. Secondly, there has not been any evidence of a handgun belonging to tactical security. Thirdly, the spent cartridge was found too far away from where accused one was on the stage. Fourthly, Larry Mavunda, now referred to by the State as accused 0, has not been requested to make a statement, being called to testify or charged with any offence. This results in a negative inference being drawn against the State. And fifthly, there is nothing sinister in the reaction of accused 2 and or Larry Mavunda before, during and after the shots were fired. In fact, all the people at the stadium, both on and off the stage, appeared to be in a celebratory mood. Accused 1 explained that the celebration included an element of showmanship or surprise when he testified. He went on to explain that what had happened at other celebrations and further explained to this Honourable Court that no prior discussions relating to the stage or toy forum had taken place because this would have detracted from the elements of surprise or showmanship. Your Worship, I note it's 10 to 4. I'm going to turn to the law, whereafter I still have comments on my learned friends' heads of argument. It's unlikely that I'm going to finish today. What I would thus request is that, unless Your Worship is prepared to hear me quickly, I can try to summarise the law as quickly as possible. And then it's still for Mr. Matthews to argue. Or we can arrange a date.
Either way, we will have to come back to hear Advocate Matthews' address, so I don't want you to rush through.
Thank you, Worship. So I'll make a note here that we're going into the onus, and if we can then arrange a date that will suit everybody with the remaining time.
Look, since it is a parted and we need to listen or hear arguments, I will leave the decision as to a suitable date to you, Advocate Holden, Scarlett's advocacy. Because then thereafter, I will be involved, but then I can accommodate.
As well. Thank you. My learned friends asked me about January. I do have some cancellations that arose in January. I don't know if Mr. Matthews is I think we're going to try to arrange a date for January. I have my diary. I approach the accused.
Required the 16th, the 17th, the 23rd, and the 24th of January.
I know the 23rd and 24th is rather congested, but either way, if you are willing that or
I see.
amenable to me clearing the court roll and then continuing to listen to arguments, by all means, any of those dates I'll try.
Can only do 23 and 24, Your Worship.
You did.
23 and 24.
Are you here in London on the
I'll
court?
come for this, Your Worship. I'm not in
That's a suitable point.
23 and
23,
24.
24, we can take both days, I think.
You have to make certain.
And as you say, you're ready. We will wait for you to do whatever
Yeah,
you need to do.
Yeah,
Thank
you
you.
see, the problem is in my absence, many cases were placed not by myself, so I had to work through court books and enter it in the diary. So, but nonetheless, if we can say for the 23rd, we set the time at 11 to give me an opportunity to clear the roll and see how far we get on the
That would
23rd.
suit us perfectly, Your Worship, because then we can fly in on the morning of the 23rd and be well before the
We
day.
can leave this. It's up to you.
Thank
Is
you.
that time suitable for the state advocacy?
Just want to confirm 23 and 24.
Yes.
23 and
I'll make
24,
myself
and
available.
then as from 11 on the 23rd.
No problem. Thank you.
Advocate Matthews? Please, the gallery, please. You can, I've asked kindly, sir, please. We are still in session. Accused 1 and 2. The matter then postponed for us to continue with closing arguments to the 23rd of January. We will again go back to the court we normally use, that would be Regional Court 4, trusting all is in a working condition on that date, and that we will then only start as from 11. I have an existing roll on both days, so it gives me a little bit of time to see what I can do. So 23 January, 1 and 2 on bail for address on merits to continue, and if need be, we will also continue on the 24th of January. Thank you.
As the court pleases. Thank you.
I think that's how I will question.
Thank you. Please be seated and you may feel free to adjourn.
All right.